Hi, my name is Behruz Amuzgar. This is the second video on shareholder agreements. In the first video, we talked about decision making. In this video, we're going to talk about provisions that deal with restrictions on transfers of shares. So generally speaking, if you don't have a provision restricting transfers of shares in your articles or in your shareholder agreement, all shareholders are free to sell their shares to third parties. However, in certain corporations, you may wish to restrict transfers of shares to third parties. So there are multiple ways to do this. One way is to have a blanket restriction and to say that sale of shares to third parties are prohibited, period. Another way is to carve out some exceptions and in certain circumstances allow the transfer of shares to third parties. So we're going to talk about some of those exceptions. The first one is a right of first refusal. So a right of first refusal provision requires the shareholder who wants to leave the company to first offer the shares for sale to the other shareholders. There are two types of right of first refusals. There's a soft right of first refusal and there's a hard right of first refusal. In a soft right of first refusal, the shareholder who wants to leave first have to determine a price and offer his or her shares at that price to the other shareholders and provide them with a set number of days to make a decision and to let him know if they want to buy his or her shares. And if they don't, then after that, he or she is going to be allowed to sell the shares at the same exact price or a higher price to a third party. In a hard right of first refusal, it's the other way around. So the shareholder who wants to leave will first have to obtain an offer from a third party, present that offer to the other shareholders, and see if they're willing to provide a payment in the same amount in exchange for the shares. If they don't, then he or she will be able to sell the shares to the third party. So as you can see, with a right of first refusal, you allow the shareholder who wants to leave to have some options to leave, but at the same time, you provide some options to the other shareholders to have some degree of control over who's going to be entering the company. The other provision that we want to talk about is called a shotgun or buy-sell clause. Typically speaking, a shotgun is used when I, as a shareholder, can no longer work with you. And so with a shotgun clause, I make an offer to you to buy your shares for a set amount or to sell my shares to you for the same exact amount. Then I will provide you with a set number of days to pick one of the two. If you don't respond to me within those number of days, then you're deemed to have sold your shares to me. So if you think about it, there are some advantages and some disadvantages to a shotgun clause. The advantage is that as the shareholder who's making that offer, I'm going to have to be fair or try to be fair. Because if my offer is high, then you may not accept to buy my shares, which means that I will have to pay you a high amount to buy your shares. If my offer is low, on the other hand, then you may decide to buy my shares at a low price. So then I will have to come up with a price that is representative of fair market value of the shares. However, the disadvantage is that in certain circumstances where I have a higher financial ability or a stronger financial ability, then I may provide a bully offer. For example, let's say the shares are split between the two of us 50-50, and let's say they're worth, the fair market value is $100,000. I make an offer to buy your shares for $70,000 because I know that even though your shares are worth $100,000, you don't even have the $70,000 at the moment to buy my shares. And therefore, with a bully offer, I can't force you out of the corporation. So typically speaking, if you have a corporation with shareholders who have relatively similar financial powers, a shotgun can be a good provision to provide an exit strategy. The next clause that we want to talk about is called a Preemptive Rights clause. What that clause says is that if a corporation wants to issue new shares, the corporation will have to offer those new shares to the existing shareholders in accordance with the percentage of shares that they hold at the moment of the issuance. So for example, if you're a 50% shareholder, any new shares that are issued, you should have the right to buy 50% of them. With this mechanism, you make sure that you don't get diluted, because if you don't have the right to buy the new shares, the pool of shares is going to increase, your shares are not going to increase, so therefore your 50% is no longer going to be 50%. This is referred to as a preemptive rights clause. There's also another provision that we want to talk about, and that's referred to as transfer rights. So there are certain events that are typically called transfer events. These are usually death, divorce, bankruptcy, incapacity, and when either of those events take place and happen to one of the shareholders, you can have a clause in your shareholder agreement that says that when those events take place, the other shareholders should have the right to buy out that shareholder at fair market value. And what's the purpose of this? The purpose of this is, again, it's very similar to the other ones. Maybe the other shareholders do not want to deal with a spouse who ends up having some rights as a result of a divorce, or beneficiary who ends up having rights as a result of the death, or even creditors in the case of bankruptcy. So when you want to have those types of restrictions and want to make sure that once your partner is out for whatever reason, you have the right to buy his or her shares at fair market value, you include the transfer events and the rights of the other shareholders. I hope you've enjoyed watching this video, and I urge you to watch the rest of the videos offered by us. Thank you.